This is a question I saw on Reddit, but it's a question I get a lot, and especially when we're negotiating with the DA and the DA is considering reducing the charge. What this questioner is asking is that they had a DUI charge and their lawyer was able to reduce it to what we call in California a wet reckless. A wet reckless is a lower charge than DUI in California, and it's only something the DA can offer. That means the judge typically can't offer you a wet reckless, only the DA can. But the benefit of a wet reckless over a DUI charge is a wet reckless only has this informal probation for 12 months, where a DUI charge will have that probation for roughly 3 years. That's mandatory by law. In addition to that, in a DUI, you'll pay a lot more in fines. You can run from $2,000 to $4,000. Your jail time is up to 6 months, while a wet reckless, your jail time is maximum 90 days. And a lot of times, if you're getting a wet reckless, there's no jail time associated with it. Also, your fines are almost cut in half. But the beauty part is a wet reckless doesn't add a lot of points onto your driving record. So sometimes, not all the time, it may not result in a license suspension. A lot of employers will request to have you have a clean driving record, or you could lose your car privileges. So what this questioner is asking, hey, if I get a wet reckless, I told my employer, am I gonna get fired? Hey, that's up to your company. If you have a company car and you have this wet reckless, it's their policies to determine if you get fired or not. So that is something we usually tell people, check with your employee manual to see if you have to disclose something like that to your employer. Some employment, you don't even drive for the job. You just go to an office, work, and then go home. Some employers don't care. Other employers do care because maybe they have some licensing concerns. So go through your employee manual, check with it, and talk to your attorney after you check with that stuff. See how that's going to affect. A lot of times your lawyer may or may not know about that company policies, but they'll go over that manual with you. We always want to make a decision that will help you in the end, not to cause you to lose your job. And if it's something that's on the borderline, then that's a gamble you have to take. Do they have enough evidence that if you fight the DUI, they're going to convict you? Or is it that they don't have enough evidence and they're trying to give you a wet reckless, but you could beat this in court? Those are decisions you make with your attorney, because sometimes it might be better just to fight the case to keep your job, or fight the case to keep any concerns you have that for licensing issues, because some licensing boards will discipline you for a DUI but may not for a wet reckless. So that's something you check with your licensing board as well. So all in all, work with your attorney in regards to this. Verify everything before you sign that dotted line at that plea form for a wet reckless or a DUI, because it might have some effects that you don't know about, but you should be talking to your attorney about. Thank you.